I saw you coming and see me in my car.
Good morning. How are you?
I was putting my books in my bag. That's probably why. Oh, shoot, that's what I do. And I was probably in my phone. Yes, yes, you were in your head was down in your phone. I was trying to get my, make sure everything clear off my phone so that it's self-proclaimed CD don't kick in. But when I see something come on the screen, it's just, I can't ignore it.
Miss
You
Archer.
redid your paper?
I sure
Alicia,
did.
you redid your paper?
I'm doing it right now, ma'am.
You did? Send it to
I'm
Miss
do-
Dean.
Okay.
I can read it off my phone. I can read it off my phone.
What my no, I'm doing it now. I'm not
I
I'm
printed
sending
it.
it now.
Oh, okay.
So,
All right.
Yes, ma'am.
Let me see.
But Lavette sent you an email.
Let me see. Alicia,
Yes, ma'am.
is she on?
Yes, I am. Can you hear
Yeah,
me?
she's on. Alicia, you can hear me?
Yes, ma'am.
She look like she's talking. I can't hear you. It's not on mute.
Can you hear me?
Alicia, can you hear me? Mikhail.
I can hear you.
Morning. I telling him I can't hear her. But let's see what he says.
I had my coworkers, I showed them, I didn't let them read my first version of the assignment, but I
Mhm.
showed them how many paragraphs it was, and I was like,
Can you hear me now, Miss Archer?
we need to do better than this. So I did it. And they were like, Leah, you need more paragraphs, you didn't discuss better. I'm like, what the hell, y'all didn't even read this to see, no, you need more paragraphs. So because I was doing it in between work yesterday.
Mhm.
Every couple minutes, someone would say, let me see, you had anything with your assignment? Okay.
Miss Archer.
Ah. She's on now. Alicia, you're on now?
Can you hear me?
Yes, now I can hear you.
Okay, perfect.
Okay.
All
You-
right.
You redid your paper?
I'm doing that right now, Miss Archer.
Okay, all right.
Yes, ma'am. Lavette said she sent you email.
Okay,
She-
all right. I'll look at it.
Okay.
I have my phone in my hand.
All right.
I'm reading Leah's right now.
Okay, okay. But with Lavette, she said that she's sick. She's not sure what it is. So she wanted to know if I could have sent her the link, and I told her that I couldn't.
No,
So-
she'll speak to Miss Dean.
I told her that. I told
Yeah,
her that.
she can speak to Miss Dean. And someone else said they wanted the link and Miss Dean said she didn't get an email. Who was that?
Melissa, I believe. I think
Oh,
that was-
Melissa. Okay, I can run to Miss Dean.
Okay.
Okay.
I think she changed her mind about. Dogging.
She changed her mind?
Class. It sounded like she was planning on coming.
Well, she already late. Okay. Much better, Leah.
Hallelujah.
You saw the second question, right?
Yes. I did not finish it to talk about. Yeah.
And then when I send the take-home question, look at the question and see, pulling from both of these, what you need. So it won't be a lot of work. If you know what I mean? If you've done it
Yeah.
properly, it's not a lot of work.
So you were already sent the second question you said?
Yeah, I sent a second question on
That
same night.
Oh, yeah?
Yes. Make sure you have it.
Okay.
The skeleton way that I did for the first time I did the assignment,
Mhm.
it helped me be able to like highlight the main points and then go back and.
And fill it in, right,
The case, 'cause
Mhm.
I didn't tie into the case, I was speaking generally,
right.
so.
Mhm. Much better. Much better. Yes. Alicia, you can send me yours after class, you know.
Okay, then. Thank
Yeah.
you.
Yeah, you can send it after class. Much better,
I
Leo.
guess I take for granted too that. I have to remind myself during the exam that I have to prove that I am,
Yes.
it's not take for granted that you know that.
Uh-huh.
Or whoever.
Right. It's Melissa and Levette coming right
Right.
back and we're gonna start.
Okay.
Okay, so tell Melissa she got the link. They didn't want me to confirm they on. And let me answer Levette. That. She get the gold too.
Ms. Archer, you don't think that even if we were to go on, and let's say have the camera. Hold
Hold
on.
on, you getting feedback.
Go on and have the cameras on or something. You don't think that's better?
What do you mean, Zoom?
Yeah, because I know you guys don't want persons to do it online, but I mean, if you could see that everyone is focused in the class, that's not a better option.
No, there are some options like that when you would actually leave the cameras on, because I did a class where the lecturer said at the very beginning, if your cameras are not on, though you have your little mic there, unmute, he will mark you absent.
Okay. Oh, wow.
Yeah, that was his rules at the very beginning.
Okay.
But I know sometimes people, I know from having Zoom classes from when we first started, some people are in the car on the way home. Some people, when we had in class, they had to work late. And so they would say, I'm working until 9 tonight. So I'll be listening. When I can, I'll join in. So like everybody have a different situation. But then every lecture is different.
Right.
You see, so you try to accommodate everybody. Some people just say, this is the rule. This is what it is. Either you could do it or you can't do it, and that's it. But I try to accommodate everybody. And then, like I say, when you answer questions, I get a feeling whether you understand or you don't understand. And as an adult, if you feel like you need extra help or you don't understand, you can always shoot an email and say, I was in class today. I had some questions. I didn't want to like delay the class or, you know, but I really need some clarification on this. So I have students who do that sometimes.
Okay.
Yeah, so it's up to the lecturer though. So your next lecturer morning may decide,
That she is fine.
she's fine with both ways.
Right.
Or she wants you face to face or whatever it is. But to me, either one works because you participate in all the other classes I had with students on Zoom. I have a class with almost 20 people. And every one of them participated when I called their names.
Okay.
Even some when they were driving and all was participating.
Yeah.
You know, so, and then I had some who had to take care of their children.
Right.
While class was going on. And they send me a message and they say during classes, I have to take care of my 2 children. My husband is at work. So I'll do my best. So I said, okay, put it on mute. If you have any questions, we could chat on it after class or the next day.
Okay.
Just write your questions down, and that's what they did.
Nice. Okay.
Yeah. So
yeah, y'all really are accommodating though.
Yeah, so it's not a big deal. But then, like I said, it depends on the lecturer.
Right.
Yeah.
Right. Ms. Archer, give me 1 second, please. I need to go downstairs and I have to go in the elevator, so this is gonna cut out. I'll leave it on though for when I come back.
Okay, I'll give you 2. We'll wait for you then.
Okay, thanks.
Okay, all right. Let me see your paper because my friend over here, she aces.
Oh,
Ms. Archer, I did not get to finish my paper. I'm so sorry. My wrist, I wasn't sure my wrist.
So where's your line? Okay, you can send it to me.
So I need to send it to you. Yeah,
Yeah, she put some notes.
so I only have to do
I
now,
went to work yesterday morning. I said, let me come out of my house because I'm not a morning person. You gotta know yourself. I said, let me come out of my house instead of sitting there pretending like I could do this. Sometime at 7:30, I was in my office. And then I'm gonna do.
no, I went and I read the case you said.
Mm-hmm.
So I see what you were telling me.
You're right.
I see what you were telling me about it, yeah. So I know what's right and right.
Did the question you sent us come from, okay, notes in a case?
I was like, can you?
Yeah, but don't worry about
Can
that.
you break that down, please?
I just felt like I
Okay.
read it, and I was like, hold on.
You probably did. You probably did read it.
And I couldn't figure out where I was like, I read this.
Okay,
One
now
of
she
these
has read the
cases.
question. She's ready to tackle it.
I
So that's
read the
happening.
question.
Yeah.
No, where is it now? Where's my question?
I know what my difficulty is gonna be for this exam, and I have to practice on it. In my mind, I understand. And,
So you have to write it.
right, so in my mind, I could just get straight to the end, like the summary paragraph of the question, without putting all the details. Like in my mind, I'm like, I have to work properly.
I have students who did an exam and they wrote me like 4 to 5, maybe 6 lines, full stop.
Yeah, no.
20 question. And then they asked me how they feel. I say, you can't be serious. But then they could have sat there and regurgitated and said, that's what you're supposed to write. You have to demonstrate, don't forget now, that you tell them in the final exam is a cross mark. And
Right.
so
So they have
it's
no
not
idea
me.
what we put in.
I know, you know, because we discussed it in class, so I know you know, but the next person don't know that you know. Has to be written. What you digging up for?
You know,
Start
I
the
look at the
question.
question. You know, that last
Question.
exam, I was the last person to leave.
Why?
I had to do myself all over
Oh, my God.
because I wrote it. And one of the questions that was a mandatory question, I ran a line. I had gone to work 5:30 that morning, left my house to review, because this was the mandatory question. And I went the line. So at the end, when most people leave, that's when it came to me, yeah, because I knew it. You know what I mean? I was like.
Okay,
I was
so
like the first one to leave and I was
Tip
scared to leave. I was like,
number
I'm
one.
the first one, I don't think people feel like,
tip number one for an exam.
oh,
I don't know about how other lecturers do it, but when I do my review, I do. This is mandatory,
Right,
these are what you select, remember we did that.
Yeah.
right.
So you know it's mandatory off the top,
It could be
you have to
there.
know.
Yes.
And what I always tell students is, as soon as they say begin,
Mhm.
you take your first sheet of paper. And you write everything down.
yeah.
Mandatory question, riddle. That was that topic, riddle, that topic. That may take you 10 to 15 minutes.
But that's
But
it.
when you go to write, you look right on that sheet.
Because that's your point.
That's
if
your
you're
point,
writing-
yes. You have to, and
Yeah.
even with the ones where you select. If you have studied, if you've already selected what you want to write on. You may not know exactly how it's coming, but you know on this topic. These are the points that
Mhm.
need to be mentioned.
And I like.
Even
the-
if the question is a little bit off, write it.
I like the
Maybe
way it's
it's
getting like the single paper, because like you say, you could just brainstorm on one side, everything that you wanna put in, because that's how I.
And I
ended up
think students
doing
do it.
it.
And that was my problem.
They attach the brainstorm people to the exam, you know.
Yeah.
Some students, do that,
Okay,
yeah.
because like, let's just say you had something in there, but passing the veil was, it was written kind of weird.
Right.
But I know it's passing the veil. I was like, I don't know what this question, but this, the point about passing the veil. right?
Exactly.
That's how I answered one of the questions, because I was like, this question, I don't know what it's really saying, but I know what it's saying.
Uh-huh.
Yeah.
Uh-huh.
Yeah, so I just wrote.
So
that's
you're
what I
at
think
the
it was.
very end, your conclusion may not be right, but you've already put.
The point.
evidence. Yeah.
Okay, yeah. Read the question to me, please.
The question is, there,
We're going over the question, Alicia,
there are.
and someone else is on.
No, that's me. I'm on my.
Oh,
phone
okay.
because I'm walking around.
Okay.
Okay.
But it is.
So we're looking at the second question is due next week.
On Thursday, right?
Yeah.
Okay.
They got it, that's the door.
Okay, so that's when it's saying that incident when the court will disregard the Solomon and whatever and go to passing of the veil. That's how that.
Yes.
Okay, all right,
Mhm.
all right. All right.
I'm mad, you know what? So
What?
I can figure out,
I
I read
you
this,
read
no,
it.
I read this. I read this in a case when I was doing like the reading.
And that's gonna itch you until you find that case.
That's it, it's a-
Okay. All right.
Alicia, you have any questions on the next question or what? Any? Oh, you didn't look at it as yet.
I didn't look at it as yet. I realize now that it was sent to my work email and I went into spam. So
Oh, okay.
Yeah.
Yeah, that happens sometimes. Okay, so today we're gonna look at company management. So far, if I put on the side here,
Oh, Ms. Hutchins,
Go ahead.
sorry, before we move on.
mhm,
So this question here, we're gonna add that to what we're giving you? Like a part two or just?
no,
Answer
separate,
that,
just
okay,
answer that.
Okay. Cool. Sorry.
And after I get that, and I provide just some general comments to you,
Mhm.
then I will send a take-home question.
Okay,
Now, you don't have to send me, you don't have to bring your take-home question on the day of the exam, if you don't want to. If you finish it, just send it in.
okay. Okay,
So you know that's out of your way altogether.
right, okay.
You will see it on the exam,
Mhm.
but you know that you've already done it.
Okay,
Now, I know some people do this. I've had it in
With
different
what?
classes. No,
Which one?
no, they write it in the exam.
oh.
Because it's a take-home question, you know it's not something that you can answer in the exam.
Right.
Because there's insufficient time
Mhm.
until they wait and answer it in the exam. And they lose all the points.
No, it's all right.
Good morning. They lose the points. Well, what am I gonna say? But she could have just moved a chair from here to there. Thank you. What they call it? They call it relax, but not relax. It's not a perm.
Like a press.
Basically,
But she pressed that afterwards.
that's them two
She
clubs.
said the chair girl.
Oh.
Wow. And then she pressed it. What she said was to soften the hair, some foolishness.
I think that was a sophisticated word for relax, I mean, firm.
No, he says not a perm. That's like a perm, but not a perm. Cause she said once, she blew it out afterwards, cause she said once I start to sweat, it'll just fall up.
Mhm.
And then she said I have to condition it every day. It has to be moist.
Oh,
So it's like it's
The press, did she probably put the
something.
keratin treatments?
What's up?
Oh, you worse than me. I think, what you wanna do?
That's why I tell her.
You for?
I don't know. She started calling all these things.
That's not my
on the
expertise.
side. Yeah, I don't know. Okay, so we did the chapter on incorporation, which is a process. And we know from Solomon that once we receive the certificate of incorporation, then we are a separate legal entity. Right? Advantages, disadvantages. We know we're different from a sole proprietorship, and we know we're different from a partnership. Each one has its own advantages and disadvantages. And we know that depends on what the incorporated company does. There are times when the courts will pierce the corporate veil. But we know in recent times, the courts are inclined not to pierce the corporate veil. Remember? Which I told all of you to read. So if you give me the one on Thursday and you don't discuss this, that means you didn't read it.
So confusing to me.
No, it is not.
I mean, just the timeline, following the timeline and.
The
trying to
ti-
put out
The
pieces.
timeline goes from
Press.
press.
Oh, something like that.
The timeline goes from when the courts first started piercing the corporate veil.
I have to like sit down and draw.
So you just, I don't draw it,
Here's
or
the company,
just
and
put
this
the-
one, And this one, and
right? So. That's what we did so far. What is a company? We did that. Now, we're gonna look at. How is a company managed? And the two key players. The directors and the officers. Directors by law have a fiduciary duty. So if you were ever appointed as a director on any company, there is no piece of document that will now say, Leah, you have a fiduciary duty. Just in this role itself, this automatically arises by law. A director has to follow the articles, and if there is one, the shareholders agreement. Because they give him the power to do certain things. Articles would also tell him whether or not he needs permission from the members to do certain things. So this fiduciary duty that a director has that arises by law, it means that he must always act in good faith. You cannot make a profit. And these are gonna sound familiar. They don't sound familiar to you? Okay, because a trustee also has a fiduciary duty. And just by that word fiduciary, those duties are the same. So he has to act in good faith, cannot make a profit, cannot put himself into the position where there's a conflict of interest. He has to act for, not for his own benefit, on whose behalf they act, but he also has to act in accordance with the memos, the articles, and he has to deal with all of the shareholders evenly.
The director is essentially the trustee of a company. In some way. The
That
trustee
is-
would be a. of a
Yeah,
trust.
same duties, the same duties. So just like how a trustee has to exercise that skill and care when he's carrying out his duties, a director has to do the same thing. He always has to act like a prudent man. Remember, in the trustee, we say he has to act like a prudent man. A director has to do the same thing. And he is the one who is responsible for the day-to-day management of the company.
The director is responsible for the day-to-day.
Don't forget, now it's the directors who will appoint the CEO or the managing director. Whenever a company is in problems, whether it's financial or it's ethical, they go to the directors. Then the directors have their nominated person, who is the CEO. And the CEO has to know how far he can go. And in the last, when we do that last chapter, the CEO and the chairman has between them the corporate secretary. The corporate secretary is that person who's supposed to know the memo and arts in and out. That corporate secretary is supposed to know, based on the company's constitution, whether it's a CAC or an IBC, what they can and cannot do by law. So that corporate secretary is the person who guides both of them. So the corporate secretary will say, tell the managing director, you need the approval of the chairman. I think you need to run this by the chairman, or this needs to go to the directors. The corporate secretary is the person who will say a resolution needs to be drafted.
So they should know the memo and arts and the articles.
Mhm.
Right now.
But we'll come to the corporate secretary last, which is a very good job.
And I,
I'm thinking about our corporate secretary, processing it, and I didn't realize that a role was so vital.
Mhm.
when in the paragraph after directors, it says that the non-executive director acting independently of the actual day-to-day of acting independently of the actual
Mhm.
day-to-day management of the company. What does that mean?
Okay, so on a board, a typical board, some private companies do it. Public companies, if they are regulated, they would have a non-executive. A non-executive director is one that doesn't work with the company or for the company.
Okay,
This is someone who has expertise
okay,
in a particular area. So on most board, you'll see an accountant. You'll have an attorney. They may have someone, but now with climate change, you'll have someone who knows about the environment to give advice. Yeah, so there's different roles that they play.
Okay.
So you all know when we did the incorporation that the first directors are the subscribers. I mean, you have the subscribers and then you have at the incorporation, and then you will have subsequent appointments. Now, subsequent appointments is based on the Articles of Association. The articles stipulate what the process will be and who can do it.
Mr.
Go ahead, Alicia.
Well, I just remembered it now that you're talking about the incorporation and all of that, right? I have a situation where I have a certificate of incorporation, right? Let's say the company number is 1, 2, 3, 4, 5 on the certificate of incorporation.
Right.
But then when you look at, so there was a merger somewhere. So if you go to the certificate of, I think it's incumbency,
That was drafted
has
by the
five.
secretary.
right? That has 5, 4, 3, 2, 1.
How?
That's how it is. But like when you do a search in the registry, you could still find the certificate of incorporation number, the 1, 2, 3, 4, 5, but you're unable to pay registry, the, what is it, annual fees on that number.
This is the wrong number.
You have to be the agent of that company on the paper.
They have, right, we are the agent.
They're the agent.
Mhm.
But you,
But-
but do you have the resolution for the merger?
Yes, and the merger has 5, 4, 3, 2, 1,
So
which is the second number, which that number is on the incumbency.
real life story, you can depend on
The registry?
the portal.
Yeah.
I have
Okay,
at least
okay.
3 companies
Mhm.
every year. We have to pay over the counter because the name, they have a name change. We have a certificate of name change system with the original name still. All
Oh,
we have
wow.
is that we have certificates of dissolution and they are still in the registry as active and owing fees.
Oh, wow.
Why can't they change it?
I don't know, they can't read the now King's English, because we send letters every year when it's time for annual fees, if they please remove this off the list with the certificate of dissolution attached. And
Maybe
send
that's why
them-
they're getting this new system then from the Cayman.
Yeah, there's a lot of like
Yeah.
background kinks that become annoying when it's
Mhm.
time to pay that.
Because I've had
Okay.
students before from the registry, and they said that when the system was designed, they didn't ask the people that actually do it.
Actually working in.
The
No,
ones involved.
and so once they got it, they
Mhm.
realized there's a lot of things they couldn't do. And so
Okay.
I understand it, because at the beginning, it was kind of like frustrating. And then they were frustrated. And then when they, you do things all the time, they've been doing it for years. But when they, did company law itself and they pull out the legislation, they begin to realize that certain things that they were doing were not even in law.
Or things that
Wow.
you need to do.
Yeah, things that they needed to do was not a part of their process.
So what we usually do, Lisa, is we pay over the counter. Anytime that we pay the fees, we request a certificate of good standing so that we'll have it on file. That if it's an issue, we have a record of the fee being paid in addition to the registry. Permit that it's in good standing.
Standing.
But the thing is, I can get a certificate of good standing for both numbers.
How you get it for both numbers?
Both numbers for same company, but I just can't pay the registry fees on one.
Yeah, but one company doesn't exist.
I can still get a certificate of good
No,
standing.
no. But again, that's the
got it.
system. Yeah, yeah, you can't use that.
Wow.
That's why we have to be prudent. We know. that
Yes,
don't
you know,
exist.
yeah, it doesn't exist, so you cannot issue that to anyone.
But the thing is, I didn't know.
Oh,
Okay,
she didn't know.
okay, I gotta come off doing some work now. But the thing
Okay.
is, I didn't know as a new person coming in. I didn't know. I just was trying to pay the fees and then.
Okay.
Yeah.
All right. Okay. All right, but that's another thing, I know where an administrator had responsibility for a particular company, group of companies. And I said, I just need to make sure that this company is current. And so if someone says to you, here's everything, you will assume from that administrator that everything is current, because otherwise they would say it's not. And so I went through and checked all these things, and then I see all these names. I see there's too many directors. It's not feasible. So I went on the company's website and I started to look up these people, and I had to go back and I said, do you know this one dead, this one retired, You see what I mean? Making mistakes. But you could imagine as being a registered agent, if you had to prepare a certificate of incumbency, you putting these person's name on it and the liability you're exposing them to, and they're not even a part of the company anymore.
It's
And
crazy.
that's how serious this role is.
Wow.
The thing that I've seen is you have.
You could hear her, Alicia?
Yes, I can.
Okay,
you have,
okay.
Like, they would do, you would do resolutions, for example, to issue shares, new sets of shares or shares of a
Mhm,
different
mhm.
treasury. And you go to fill out an incumbency, create an incumbency, and then you realize the resolution was never signed. The shares. Was
Yes,
never
yes.
signed. So how you want me to put on here that these people receive shares if they legally were not issued shares, like stuff like that, you just have to be. Until you really like focus on the details of knowing like the M&As to know that, okay, who's actually supposed to sign this resolution?
Mhm,
Because if the
mhm.
M&A say it can't be done by the directors, it have to be done by the shareholders and the director sign it, then it's
Yeah.
it's not.
Or you could have where there are two directors, right? One director wants to remove the next director. And they send instructions to the registered agent to remove the director. And I had to tell the administrator, go to the articles and see what it says. They're in the deadlock. They're in the deadlock because neither wants the shareholder to know. You see what I mean? So you are stuck here. I said that matter now becomes a legal matter. Take that to legal. You can't deal with it. So, and then you have sometimes some directors, you see that fiduciary duty, some administrators don't know that a director has a fiduciary duty. And sometimes directors, based on instructions that they send, are trying to do things underhandedly without following the articles. And you have to tell them that no, the director cannot do that. But why? Because as a fiduciary, he has a duty. And he always has to act in the best interest of the company. Is this decision in the best interest of the company?
Miss Archer,
Yes.
is
Good morning.
excuse me. Good morning. Good morning, class. I have a quick question in terms of the directors.
Mhm.
Could a director also be the CEO of the trust company?
Not the trust company. You mean just a company within
Of
the
a company. Sorry, yes.
Can he be a director and CEO?
Yeah,
Or director and shareholder?
director.
Director and CEO, or just director?
Director and the CEO of the company.
Depends on what the company does.
Okay.
And does he own, and he owns all of the assets? He's the settler of the trust?
A few, but not all. You're not settler. No, a protector.
Or he's the protector?
Yeah.
And he's the CEO and director of underlying companies?
Yes, ma'am. I had seen that case, as I was wondering.
Have you checked the trust deed?
No, I didn't get the
You need
chance.
to check the trust deed because it may be in the trust deed that
Okay,
he's appointed in these roles.
okay.
But that
'Cause
doesn't
I know
sound like a
too.
conflict.
That's typical.
No,
Okay.
Okay.
yeah, it's not typical. That's why I say check the trust deed.
Because like when they
He's
have
supposed to
board
be giving
meetings.
advice and stuff. I don't understand why he would be a CEO and director.
Yeah, like I was wondering too, like when they have board meetings,
Mm-hmm.
he is present. But he is also the CEO.
But because he's present at the board meeting, that does not necessarily mean he's a board member. He can be an
No.
invitee.
Yeah, is he an invitee?
No, I'm not sure.
But you
But
say
I
he's the
know,
CEO.
yeah, he is the
He's the
CEO.
CEO.
Maybe their logic is because we protect the assets of the trust. He needs to have a final say in the company that.
Maybe, as I've said, that's you have to read the trust deed.
Okay.
Yeah, you have to read the trust deed and see what powers they gave to him. Remember when we did trust, I always say, whenever you're dealing with a trust, the first document is the trust deed, and you have to check the powers. And then from there, then you have to read the articles of every company because they're not all the same. It is a lot of work. So on appointment, a new director has to sign, as I give his consent. He can sign a service agreement. Normally they would ask if there's any insurances, any indemnities. And the corporate secretary would then provide them with any of the corporate documents that they need. So that would be the M&As, any financials that they need to see, any previous board meetings. And the corporate secretary also has to sit down and advise the director of all of their statutory and regulatory obligations. So there are two types, which we mentioned earlier, the executive who works for the company and the non-executive who doesn't. And remember, in law, there's no distinction between the two directors. They're still both fiduciaries. They have the same legal duties, same responsibilities, and same liabilities. Now, in some instances, some FCSPs have nominee directors. So these are companies that they have incorporated to act as directors. And they normally do that under a corporate management agreement or nominee directors agreement. And then you have persons that are known as shadow directors. And these are persons who are not appointed. And they may be as liable as a regular director. So shadow directors are not formally appointed. In our legislation, shadow directors are recognized, have been from 2011, and they define it as any person in association with whose directions or instructions the directors of the company are accustomed to act, but the person is not deemed to be a shadow director by reason only that the directors act on advice given by him in a professional capacity. So this is someone who attends board meetings frequently and who in the meetings is giving advice, on a regular basis, gives advice on different topics, but he is not appointed as a director. That is a shadow director. And if you are considered to be a shadow director, then of course you're liable and you have legal obligations like any other director.
Oh. The person is not appointed,
No,
but they are known as
yes,
a shadow director.
no, they're always at the meeting and they give advice.
So because that's what they're doing, the mere fact that they're doing that, they still have.
So
to
let's
tell
just
them.
say, yeah, so let's just say that person gave advice and the board agreed. The resolution says that the board agreed so and so. So let's just say based on that, whatever the matter, let's say the matter was a contract with another company. Something happened and they decided they're not going to finish this contract and the company said, I'm going to sue you. Then they look to see who made the decisions, who were present at the meeting. And when you look at who were present, this person here is not an appointed director. So the question then comes, did that person act as a director? And acting as a director means that they're a shadow director. So then you have to determine whether or not that person wielded influence over the other board members, and if it was on a consistent basis.
Question.
Then they would bind, that person would bind the company.
So let's just say we're in a meeting, I'm a shadow director, and I was like, you guys should do so and so and so. But the minutes probably won't reflect that I said that. It'll
But
be
the,
like
but
directors
but the
agreed.
minutes,
Yeah. it
but the
would be like
minutes
a
have to say
plot.
who's present.
Okay.
So a good way to.
Because you know, normally they'll put, like, if you went in to make your contribution, they will say so and so presented and left.
I like to clarify all aspects of it. So to protect yourself from becoming a shadow director, could you then have like a consultancy agreement with these people, maybe a non-paid consultancy? agreement where I give advice that-
Yes,
Okay, yeah, so now I'm not a director, you actually. Okay.
yes. And that's why it's so important in when you're dealing with, see, this is the beauty of a company. Notice everybody is creating a company. That's how, that makes it the line clear when you're doing business. Because you're not doing business with me. Even though I come as an agent or as an employee. You're doing business with ABC company. And so that means there's always an agreement between you, not in your, even in your personal capacity. It could be you, and it could be you acting as an agent of your own company. And I acting as an agent of my own company, but it's company to company. That's the beauty of incorporating a company. And that's why I was telling you, having these IBCs for foreigners in the Bahamas is like having a stack of credit cards. Each one is for a different purpose. So director's duties, and I don't have to go through these because you all know each one of these from a trustee. The duty to manage the company, act in the best interest, act in accordance with the memo and arts, act in good faith, and how to treat the shareholders, the different classes fairly. So in the case of Reese Smith and Fawcett, it spoke about how directors must act in the best interest of the company, and they can't use their powers to benefit themselves or third parties. And you would see sometimes in contracts that persons have as a director, there's always that clause saying that you cannot take confidential information and then form your own company offering the same products and same services. Some contracts would give a time limit. Some may give you a period of 6 years, some will say 3 years, some will say 1 year. And I still wonder how come every time they say these are the new cars are just coming out, they all look the same. That always comes to me. Every year they said that, I said, no, cannot be right. How come all look the same? You notice that?
So that they get sell parts for multiple years. It's the.
Yeah, but they still look the same.
Brand.
No,
You mean,
no, all.
so she means Mercedes comes out with a new whatever, and BMW.
Come up with the same thing. Audi, they all look alike.
Because they all share technology. They all.
No,
share
but the technology is
and
inside.
manufacturing.
There's the outside.
I mean, for manufacturing, they all using the same stuff to build these cars.
Yes, but
So
why
they
should
look
all
the
out?
same.
No, they all look the same. Remember?
Sasha,
Yes.
Siobhan just messaged me.
Mhm.
She's still not feeling well, and she asked if she can please get the link to join.
Yes, because
Just gotta-
Miss Dean asked if she was feeling well, you know. Hold
Yeah.
on. Tell her
I
call
can
Miss
email it.
Dean. She
I
called
can
Miss
email
Dean.
it. Can I email it to her?
Email Miss Dean.
No, I mean if I could email it directly to Siobhan.
Yeah, send it to her. Yeah, because she did ask.
All right then, thanks.
Mhm.
So that link is really, because Thursdays, they will be good on.
Yeah.
Yeah.
I was trying to.
Yes, lady, yes.
I might, you know, she's telling me. last
Well, then you
Sunday,
leave.
Sunday,
Talk to Miss Dean.
she said-
Because we already spoke
Oh,
about that
okay.
this morning, right?
She said, this must be like, really. It's supposed to be off today.
They are cool, man.
My poor little godchild, she had a 2-year-old.
You?
Yes, it's very rough. You ain't got to school yet, Cardi. I'm like, okay, mother. Going now.
You need to talk to Miss Dan. But she did ask if she was feeling well, so. And I said I hadn't heard anything.
I just sent it to her, so she should be logging on shortly.
Okay,
All right.
she's taking on the books. Let me run. Let me tell her.
No, she has to go with me. Oh, she have to get up, get ready, move like snail. Get breakfast. Fix hair. And make it new. I want to tell myself, I won't marry you, you can do it, just continue. Keep going, one step, the next step, yep.
Alicia, you sent it to her?
Second. Yes, ma'am, I did.
Okay, all right.
Decent setup today,
Huh?
we got a decent setup today.
You see that, eh?
You didn't drop off the line today.
No, we were saying to be okay. All right, so yeah, that's what happens. It's I don't understand. All the cars look the same to me. It's the same. So a director himself, when he is exercising his powers, he has to use it for the purpose of the company. And he has to make sure that when he does it and he exercises his discretionary powers, that he does it independently and fairly. Which means that he has to make sure if it's involving shareholders, that he is doing it even-handedly. And he also has to make sure when he's dealing with external parties, that he's still again doing it fairly and independently. So the case of Movitex and Bullfield, that case established that directors do not have a duty not to place themselves in a position of conflict in and of itself. They should not place themselves in a position where their personal interests or their duties to third parties conflict with their duties to the company. So you'll have a lot of that. You see that even here when persons are appointed as directors and they see opportunities and they say, okay, I could create a company and then I could propose my company or my family company, because they could put their family as being shareholders and directors, but I can propose my company to provide services to this company where I am a director. And that's why you see a lot of people are being hauled before the courts. Because that's what they're doing. They're putting a company that they are related to act. It's a conflict of interest. So even though you don't own the company personally, the conflict of interest arises because you are related to the persons who own and operate that company. And that relationship needs to be disclosed prior to the matter being introduced. So before the board even decides to vote to engage that company, the conversation should have already been made by the director to the chairman and the corporate secretary. Here's a list of the companies that I am affiliated with. And affiliated with doesn't mean that I am a shareholder or I am a director. It also includes any company where you act or your relatives, spouse, sister, brother, uncle is a conflict of interest. It has to be declared first.
Yeah, and that's why now, like, even when you're applying for jobs, they ask you to disclose that information like on the application.
Mhm. But some people don't understand conflict of interest. They think it means direct. Like, I don't own that company. My cousin owned that, so why do I disclose it? It's still a conflict. So directors may be given consent in the articles of association. And that's why I was telling you the role of the corporate secretary is so critical. Because they need to know what a person can and cannot do. And of course, it can be done by an ordinary resolution of the company. So directors are also prohibited from gaining a profit or obtaining some benefit by using proprietary information, trade secrets, or opportunities that may belong to or derive from the company for which they act as directors. So in the act itself, 84 of the CAC and 40 of the IBC, they stipulate the duties of directors to manage the business and affairs of the company. And they also say it's subject to the limitation in the memo and arts. And of course, in some instances, the unanimous shareholders agreement. So one of the primary fiduciary duty of a director is to always treat shareholders fairly, because they must always act in the best interests of the company. So in the case of Mutual Life and Rank, it said that the shareholders of the company are one of the primary stakeholders within the corporate governance regime. Because remember when we started, when I opened the class, I said that when you study company law looks at two main functions: corporate finance and corporate governance. Corporate finance is how a company goes out and raises money. Corporate governance is how you manage the company. So within the corporate governance regime, you have to be treated fairly in the proper distribution of dividends, where applicable, the allotment of shares, access to company information, and when you make corporate decision, you have to refer to the memo and arts. So once you are a director, then you have all the powers that are in the Articles of Association. But their powers are not unlimited. They could only exercise those ones that are in the articles or in the unanimous shareholders agreement. And of course, the law itself restricts a director's powers. The articles could also permit the directors to delegate certain powers to management. But when directors sit down and they vote on a matter, they have to act collectively as a board, because then what they're doing is they're binding the company. So any breach of any of those duties exposes the director to liability when he doesn't carry out his function in accordance with his fiduciary duties and his powers. So a director cannot be liable for fraud, criminal, or bad faith of his co-directors if he didn't take part in it, or he had no knowledge or no suspicion. But if he is involved in those acts, then he's jointly and severally liable with his co-directors. And of course, he'll have to make good the whole loss with a contribution from his co-directors. Of course, if he does it by himself, then he is liable for all of it. Directors may be liable to account for any secret profits that he made, just like a trustee is liable to account. And the company will be entitled to avoid any contract that he may have made. Now, under the case of Bamford and Bamford, it says the company may by ordinary resolution waive a breach of duty by a director. And the court has the power to grant relief to a director who acted honestly and reasonably, and who, in review of the facts of the case, ought to, in the circumstances, be exonerated. So being a director exposes a person to liability. And many directors like to seek protection for that risk exposure from their company and its insurers within the legal limitation that is imposed by statutory and common law. So they like to make sure that they have some sort of indemnification. So in the Companies Act, they allow a director and his legal representative to be indemnified by the company against all costs, charges, and expenses which may be reasonably incurred in respect of any civil, criminal, or administrative action. So in addition to when you're appointed as a director and you sign your agreement, you have to read the insurance coverage, because you have to see what you are protected for and how much. So a lot of persons sign on as directors and then realize that they have no insurance. But there is indemnification. Under the IBC Act, it also allows a director the same protection. And of course, that's subject to any limitation in the memo and arts and the unanimous shareholder agreement. The statutory right to indemnification is only permissible to directors and their legal representatives of both the CAC and the IBC, provided those directors acted honestly and in good faith in the best interests of the company, and where they had reasonable grounds for believing that their conduct was lawful in the case of a criminal or administrative action or proceeding involving the company, and that is enforced by a monetary penalty. So since directors and officers may be personally liable for any party that may have in an interest in the affairs of the company for damages, legal costs, and expenses in relation to a breach of their duty, many of them seek the protection of directors and officers' liability insurance. And that insurance is designed to protect the director or officer against claims that may be made by a company, a shareholder, or creditors. And that's why you see some people decline when they're asked to be a director.
So that's different from the indemnity.
Indemnity is by law. So under the Act, a company may purchase and maintain insurance for the benefit of a director against liability. So some companies have that provision, that coverage, and they'll tell you the extent of how much the insurance will cover. Under the IBC Act, it allows a company incorporated under that act to purchase and maintain insurance for a director, a registered agent, officer, or liquidator against liability incurred when they act in that capacity. So notwithstanding the provision and protection of directors and officers' liability insurance, executives and non-executive directors ensure that they are properly and sufficiently covered when they agree to accept the act in the capacity as a director of a company. Careful examination should not only be made of the coverage, but the extent of the coverage. Because sometimes the insurance stops when you resign. And some insurances go for the next year. So you have to read it and make sure. So most persons, when they're appointed, the first thing they ask is, can I see the insurance coverage? careful examination, like I just said, should include looking at the coverage. So I gave you this a little insight here about Enron and WorldCom. The negotiated settlement agreements of many executives and non-executive directors of those two companies to make substantial personal payments beyond the coverage offered by their liability insurance. In last year's securities class action litigation, it is a modern day reminder of the limitations of personal protection from liability when acting as a director. And if you remember those two cases, those directors were not acting in the best interest of the company, but only of themselves. So newly appointed directors will be advised to seek an independent advice and review of the indemnification and insurance coverage offered by the companies and the extent of their personal claims, actions, and proceedings if a litigation arises. So since directors and officers cannot rely for protection on the separate legal personality of a company, and for the company, and the protection is provided for the company's assets in respect of reimbursement of directors and officers, indemnification and insurance coverage should be a primary consideration in the exhaustive list of requirements of a company before accepting to act as a director. So let me ask you, if you were to be appointed as a director, let's start with Janice. If you were going to be appointed as a director of Commonwealth Brewery, what do you think you should put on your checklist?
So I need to make sure they have insurance
Mm-hmm,
for me. Or for the director, sorry.
mm-hmm,
I need to make sure. I need to check did they give me the memo on occupancy review?
mm-hmm. So before you do all of that, what's the first thing you'll do?
The first thing.
Mm-hmm. Very first. Remember, my questions are always practical. What's the very first thing you will do? Hmm? No, no. First thing.
Whatever it is, my duties are going to be. No.
No. What's the first thing you will do? You. I'm inviting you to sit on the board of Commonwealth Brewery. What's the first thing you're going to do? It's just like. Huh?
Make sure the company has no.
That's a part B.
Oh,
That's B. What's A?
what, making sure, I tell them I have shares, or,
Give you all that, yeah.
okay.
It's a disclosure.
Oh, the disclosure, yeah.
But what's the A bar?
Well, finding out what the company's about.
Thank you.
Okay,
That's
all
so
right,
practical.
okay,
Yes,
what
practical.
it's all about.
Not everybody when they hear, oh, well, I want you to sit on the board. Okay, no problem. You don't know the first thing with the company. You don't know if it's making a profit or not.
Right, okay.
You don't. And you don't even know who's sitting on the board.
Right.
So there's disclosure to be made from all angles.
Mm-hmm.
All right, so now you did that.
Mhm.
What next you going to do? You've decided you'll take it.
I'll take it.
Mhm.
So at that point, then they should be able to then provide me with some of their information, right? Like I would want to see the financials. To see if the company, what the company is making a profit or not.
Mhm.
Make sure there are no legal actions against the company. Then check and make sure they provide their directors with insurance, make sure I'm covered in that thing.
Mhm. Anything else, Leo? Is she writing these down now? Repeat?
And then I guess you'd ask for all of the corporate documents as much as they'd be willing to share.
What do you mean willing to share?
At that point, they should be, that's what I'm saying.
Yeah, at that point, once she signs that she agrees
So
to be a director,
You know, my brain work, I put on here background check for the company, and in my mind,
Yeah.
that's like do a KYC as I would for a client. So I need to know where. to
Then that
go.
KYC you're doing, you do that before you say yes.
But in some
Yeah,
instances, they
yeah.
might not give you.
They might,
no.
but she could go on their
You're
website.
doing your own KYC.
Yeah.
So you have to do the KYC on them before you say yes.
Cause they might tell me, they might tell me who the directors are, but then they might not tell me who the shareholders are. And then what if I have a direct connection to somebody who's a shareholder that I didn't know after I raised it yet?
If it's a public company, you'll know who the shareholders are.
Yeah.
Mhm.
I don't see, I wanna know everything.
Yeah, but you need to know. Because of conflict of interest, you need to know. You need to know who they, see, the part you left out is
Major businesses and what they do.
The powers of
the
the.
stakeholders. Let's put them in one bucket. Who are your stakeholders? Who do you do business with? Who are your vendors? Employers, employees? All of it. Because disclosure is important. That's why you get yourself in problems. With these people who don't understand what conflict of interest mean.
Everybody in Nassau from a public event.
But you need to disclose it. If you disclose it. It's like the last time when Brent Simonet was. The last time. When it was his company. And he had to resign. No, it wasn't post office, again, was his paving company.
Yeah.
Road,
yeah.
yeah. But I mean, we all know he owns it.
Yeah.
It's public knowledge.
Mhm.
So why does he have to resign when it's a known fact that he owns it?
Right. I think one thing that's coming to mind is. Disclosure can't just be me saying, like, you have to make sure that there's something in writing that the board knows and they've accepted it. Cause. They might say, okay, yeah, it's fine, and then 2 years down the line, a new board member comes on. And they wanna try to make an issue of it, because there's nothing on the record to say that we were advised that we.
So who's responsible for that?
The public secretary.
Corporate secretary and the chairman.
Personally.
But then you can get a waiver or something, so that I.
Hmm?
Can you get a waiver as a director or whatever?
You normally don't sit in the meetings when a decision is being made,
Okay.
but. It's a known fact that, okay, let's take the street lights. I have a company. The only person in Nassau who could bring in these lights and install them. So we're having a meeting and they're saying now that they need to do this. I'm the only person. So it's a known fact. So the corporate secretary should make a resolution for a show of hands without me being present, that they know that I own this company and they are prepared to do business with this company. That's one. And two, they have actually gotten quotations from other companies outside of the jurisdiction or other companies locally who can recruit people to do this job, and this is the lowest price. So it's not about the person, it's how you run the company. And that's why I always, when I teach, I tell you, I'll get practical, it's practical. They don't do things practically. They just jump straight from the frying pan and they just decide, no, can't happen.
I don't think it's a bigger picture, because how do you prove from a business standpoint, if you take names off of the bodies that are present, so it's no longer personal, how do you prove from a business standpoint that body A is better than some other body to do the work that you have?
Exactly. And that's why we're just stuck in this mold where we're just going around in circles. Because they're not actually running and operating it like you would do a company. That's the problem that we have. They're not business oriented at all.
Yeah, we do companies for that corporate veil.
Yeah,
That's the
that's about
purpose
it.
of it.
Yeah, that's the purpose. Not to actually function. For us to move forward. It's just, like you said, it's just a veil, just so you just don't know who the person is. Pass exam question. It's a cheat. You could read it, Alicia. Levesque.
No, I just see given the changing environment, that's all I can see.
Stop it. Okay, a director
Oh.
is expected to act. A director is expected to act in the best interest of the company. That's a statement.
Deandra, you can write it down for us, please.
I will.
Thank you.
Welcome.
Given the changing environment and influences in today's society, what advice would you give to a newly appointed director of a private or public company? 10 points. Hmm?
This is a big one.
We're gonna discuss it. That's a past exam question.
Oh, okay.
So that's our question from which chapter would look, one of them. Mhm. Okay, Marissa, we'll start with you. Look at she taking picture. I want your brain. And then, officers. Both legislation speak of officers. Because you know who the officers are, right? What do you mean,
I don't know.
You don't? Mhm. These are the persons that have the authority to transact on behalf of the company. If I put here Easier for you, right? The persons who are authorized to act on behalf of the company. Let's see. And of course, then there will be the secretary. See. Let's use different names. So just like in the fiduciary, they have the standard of care. And they have to act honestly and in the best interest of the company. And in those positions, persons in those positions should have the requisite skills to carry out the function.
What is that?
Which one?
Articles was on the other side?
Yes,
Uh-huh.
unanimous shareholder agreement.
The sole proprietorship and the advantages, disadvantages to the left.
Mhm. All right, so let's look at that and then we'll do nominee shareholders. Who's going to go first? Javon, you can talk or you still?
Didn't we just say the answers? Why would we-
Yeah. Okay, question
Okay.
number one.
Okay, so if you were going in the exam, right? All the points that Janice and Leah just put together is what you put on your cheat sheet. You agree?
Right.
Okay,
And then you gotta talk about it.
so, but when you walk in the exam, you see this question. Answer this. Using the same points that both of you just spoke about.
Well, the first thing that we want to do is to find out or advise them to find out some background information about the company itself. What is the company, what does the company do?
Before you do that. You gotta
Oh, this is
set.
the newly appointed, sorry.
Yes,
sorry.
yes. You were newly appointed.
This person. is-
You were newly appointed, you know.
No, I was asked if I wanted to be,
Yeah,
but right now I'm appointed, which means.
no, you're newly appointed. So,
Oh, then I have to accept it.
uh-huh,
Okay.
but you see, you have to start the question off by talking about changing environment and influences. So you have to set the examiner in the mindset that you understand what is happening in the world of company law. Now, one of the main things that locally what we see is people don't understand what is conflict of interest. That's one of the main things. And there is a changing environment when it comes to conflict of interest. Because internationally, persons, when they have conflicts and don't disclose it, they are sent to jail. Aha. That's the changing landscape. What about the influences? Who's watching us?
Everybody.
Okay, and you hear them always talk about corruption index. No, that's for banking. There's a corruption index for businesses in the papers. You bring it all together. Huh?
Unofficial corruption.
Yes.
exposure.
So when you talk about here, what advice would you give to a newly appointed director? Bearing in mind the changing environment and influences, what's the first thing you're going to tell him?
Need to be prudent, with the decisions you make.
Okay,
Remember
I want that one word.
Remember your fiduciary.
There you go. That's where you start.
Fiduciary responsibility.
Yes. Because if he's just someone who just walking up the street, so-and-so MP's friend, and he's going to be appointed as a director, he needs to know he has a fiduciary duty. Ah,
I have a side question. Question.
and then you could go into all the other points that you made.
Yes, sure.
Mhm.
What do you have over, influences?
Corruption index.
Right.
Now you see how easy that is?
That's the hardest part, breaking down the doorstep.
Of course, that's the hardest part, but if you have your little sheet with your little points. You see, because by the time you finish breaking down the question, those 5 points which you said, long gone.
Yeah.
You remember them probably tomorrow.
I know that was a bond we were supposed to pick.
What, who's we? No, who's we?
Plots.
Because some people have already spoken.
Plots. Oh, they did?
Yes, they did.
Oh, Miss Asha, I was so upset that I didn't know about the cheat sheet.
I just told them about it.
This morning.
Okay. And now that I know, it's gonna be great.
You don't bring it in the exam, no. You write it in the exam when they say begin.
Rewrite it in the exam. Oh, okay.
If you study it, you, when they say begin, that's
Don't talk
the
to me, don't
first
talk to me.
thing you write. Yeah, don't talk. All you're waiting for them to say is begin. And you write it down.
So what are you writing on the cheat sheet?
If you study, what you remember?
Cause remember, okay, that's how I put it, then, remember when you got our, some of our, responses the first time we did the assignment, and it was bullet point? So you write on the bullet point, and then you go back, and you add plus to the bullet point.
Oh.
So you make a discussion,
Mhm.
so you just like, if they are, what are the steps, so like do an incorporation, write down all the bullet points, and then go back into detail. For each one.
I was telling the doctor in the last exam, one of the things is I went blank. If I had that cheat sheet, I would not have gone blank,
Mhm.
because I would have had, it was so overwhelming to me, because it was like so much information.
And if you start writing something, and then, hold on, wait, what comes up next after?
Yeah.
Because you're getting ready.
I had done that.
Right.
Right.
Let me, at least I know one of them then. I don't know. So, yeah, tip out using word unbanned. But a part of the process is that it also includes this.
Yeah.
Say what order it come in, you just know that it is a process.
Mhm. So that's a very easy question. But you just have to think. Yeah, but first you have to answer the question.
Address everything at the question.
All right, nominee shareholders and beneficial ownership. So I don't even need to do a review.
We're going through the points again. Just so, you know, we're clear.
Say we going through the points again. Janice, give her the points.
Well, fiduciary responsibilities, you have to make sure,
Mhm.
then do a background check. No, sorry, a background check on the company. Make sure you inquire about the insurance.
Insurance. Mhm.
Make sure you inquire about the insurance. Make sure you advise them if you have any conflicts. And you'll ask,
Disclosure.
yeah,
Mhm.
disclosure. Then you'll also ask them to see the company's, articles. the
Memo,
and
arts,
the
minutes, the
all that
financials, all
stuff.
of that.
So you can see exactly what the business, what has been happening, what's
Mhm.
been going on.
And then you'd want to know who their stakeholders are.
Yeah, who's the most important, but then you would know too, if there's a conflict.
Conflict, yeah. Mhm.
Yeah.
Because when they speak about their stakeholders, they will also include in that any regulatory or approval bodies that they go to. But sometimes like you would know, like a particular company has to go through ABC company. And then you realize, oh, hold on now, my auntie sits on that board over
Right.
there. I got to disclose that. Yeah.
No, to get anything done, they may have to go to the securities commission for everything.
Exactly. So you need to know, because you are just
They have
being
to go to the
appointed,
Securities Commission for
right,
the top
or my
position.
niece or whoever, and then they'll ask what position that they're in to see whether or not there's an actual conflict. Because the island is just so small. So you need to disclose. And you only know if you ask questions.
So Ms. Archer, on average, for these 10 points,
I thought this was a general question. She back to this now. Okay.
are you expecting like a 2-page and
This is in the exam. No,
like a page?
no, it's too long.
It's just making sure whatever it takes for you to get those.
Those same
same
couple of points, that's it.
Yeah.
Okay,
Mhm.
so this question here, you want us to do this homework as well?
Mm-mm.
Oh, okay.
Why?
No, I just
Maybe
asked.
No, the next one. Huh?
Would there be a question similar to that on the?
There'll be a question on a topic,
But not similar to this.
not in those words. But it'll be on a director and his duties. Any questions? Siobhan, Levesque, Alicia? We good?
Yes, ma'am.
Oh, God, please don't come to church tomorrow.
I will.
She's terrible.
What was the question? I just came back to the computer. What
No,
we
to
at?
see. I asked them any questions.
Oh, no. I
Okay,
could-
okay.
Thank
Because
you.
Deandra wanted to know if the question was coming on the exam just like that. And I told her, no, it'll be on directors, but not like that. All right, so now you have nominee shareholders. And the nominee shareholders could be an individual, where they would do a declaration of trust, or you could have a corporate entity. And they would hold the shares either directly or indirectly on behalf of the ultimate beneficial owner. So the shares will be registered in the name of the nominee shareholder. But you can't read.
Almost every day you did like that. But that-
I'm really trying to make
I don't think we can buy one. Last week.
Yeah.
You mean in Cape?
Yeah.
Yes,
they
yes.
put it in the lawyer held it,
Yeah.
as an-
Where are you?
Yeah. Fiduciary duty, unanimous. Shareholder.
Unanimous shareholders agreement.
That is not that.
Yes, it is. I can't see UNANIMOUS. It is right there.
Gotcha, it doesn't have to be disclosed that a shareholder is a nominee shareholder, right? You don't have to
No,
disclose that you're-
uh-uh.
Yeah.
But that's one of the reasons why you want to do that. right?
Exactly. And to see when you like how we had that breach, you could imagine if the name of the ultimate beneficial owner was on there, they would have been all around the world. Oh, Leo owns 50 companies in the Bahamas.
Like that, I gotta change my name.
Oh, this person owned 10, this one owned 5. And then they want to know where they can get the financials to see how, no. So for very, very ultra wealthy persons, they're all held in the nominee capacity. So like I have in the notes here, nominee shareholders are used for anonymity and convenience, particularly for offshore clients. So the provision of such services must be offered to clients whose identities, business dealing, and character have met and surpassed the KYC. You have to know these clients. And by knowing these clients, how it's normally done is you would offer the service to clients that you know already. Like clients who you've done some business before, they would normally incorporate 1 or 2 companies. Then they decide to expand their business. They're doing 5 or 6 companies. The only thing you have to do is just update their KYC. But you know who they are, you know which jurisdiction they operate in, you know who they do business with. And as an FCSP, you don't physically have the financials, but you know the nature of the business of the clients. Financial corporate service provider. They provide registered office and registered agent services.
Should it be that a nominee shareholder then is essentially a trustee for the UBO in terms of they have to safeguard the responsibilities that a shareholder has on behalf of the UBO?
They don't use that word trustee for anything but trust. He's an agent.
Okay,
Yeah, it goes into contract law.
okay.
So what he actually is doing, the nominee shareholders, he's just holding the shares in his name for the UBO. And then he acts as an agent. So as an agent, he owes the same duties and responsibilities of the UBO. And it's just like how you have a principal and agent. Like if you have someone who acts on behalf of a company, he goes out and transacts on behalf of the company, he's an agent. So a nominee shareholder acts in that same capacity. So he has to act within the limits of the nominee shareholder agreement. So in consideration of that agency arrangement, the duties and obligations are inherent in that relationship. The potential liability of a nominee shareholder would normally be one towards the ultimate beneficial owner. You understand that, right? Because he's an agent of the principal, his liability lies with the principal. So it's just like someone who is transacting business on behalf of a company. They are liable to the company because that's what an agency relationship is. So one toward the beneficial owner of the shares for breach of warranty of authority if the nominee shareholder exceeds his actual or apparent authority to act on the principal's behalf. So as a nominee shareholder, and he has a nominee shareholder agreement, his powers and authority only extend to what's within the 4 corners of that document. However, the principal can ratify any action that is done by the agent. The provisions of the nominee agreement between the UBO and the nominee shareholder should always state clearly and comprehensively the relationship between the principal and the agent. The authority that he has to act on behalf of the ultimate beneficial owner in that capacity. With regard to third parties, the nominee shareholder has the same liability as an ordinary shareholder, which is liability for any amount that remains unpaid on shares issued to him in a company limited by shares. A strict interpretation of a nominee shareholder arrangement may cause some legal academics to surmise that the potential liability of a nominee shareholder is in reality a legal fiction, because a nominee shareholder has no real liability. Any legal obligation or liability with regard to the shareholding remains the obligation of the UBO. and not his agent or representative. The potential liabilities of a nominee shareholder are not to be confused with the potential dangers of providing such a service to offshore clients, particularly in a financial environment where sophisticated white-collar criminals seek to use offshore companies to hide or launder money for their illegal activities. So that's why the KYC is strict by FCSPs when it comes to incorporating companies and providing nominee shareholder agreement. It is a requirement in any risk-based approach to implementation and enforcement of customer due diligence, policies and procedures, systemic monitoring and reporting of companies with such nominee services should be established and maintained within an organization's compliance culture and legal framework. So just as in the same way in banking, you would risk rate a client. In financial corporate service, you risk rate the companies. So in order to provide nominee shareholder services, you have to apply to the central bank for a license. The nominee trust license is obtained by a restricted license from the central bank. And what it says is it holds securities and other assets in its own name on behalf of clients, but it carries on no trust business. The minimum capital is $10,000 and the fees are $2,500. So notwithstanding the nuances of a nominee shareholder agreement, one should note that under company law and in consideration of the legal underpinnings of an agency relationship, once that ultimate beneficial owner dies, those shares do not belong to that agent, the nominee shareholder. It devolves to the personal representative of the UBO. And remember what personal representative means. That's a collective term under the law of succession. So personal representative could be either an executor, executrix, or an administrator. You're looking at me like you lost.
Lost.
Why?
I'm just listening to it all confident. Could we then consider a nominee shareholder similar to like a proxy?
No. He's an actual agent. It's an agency relationship between you and I. So I stand as an agent. I stand in your stead.
Okay.
But my powers are limited to what we agree to.
Okay.
But you could ratify things that I do outside of my limit.
Okay.
So that's why it's a contractual agreement. Following me?
Shareholder.
Mhm.
Dies. Okay.
Okay. Make sense now?
Okay,
Mhm.
so this is making good sense. So
Okay.
the shareholder value. And it goes to the personal representative.
This is a collective term, remember?
Who is the personal representative? That's what.
One of
the
these.
exact, okay, of the will.
Depending. If they died with a will, you use this term. They died without a will, that term.
Okay.
Collectively, they call that. So when a person died, you're not sure whether or not they died with a will or without a will. So you say personal representative.
Okay.
And then once you know, then you use these terms. Male and female, and it's just one. I can take it off now, you need to draw it.
I have a question.
Go ahead.
Will the person ever be disclosed of under that nominee relationship? That's only be by law, you have to disclose it. Like, would there ever be a reason when that person has to be disclosed, like who the ultimate will, ultimate.
Yes, in the corporate will,
Okay.
otherwise you wouldn't know.
So for even.
Because even at the registrar, you don't know. For
for
boss,
boss
yeah,
purposes, they would have to be.
but that's only between the FCSB or the company and the attorney general's office. That's it.
All right. Okay.
Because you know, they normally have this fight when you transfer companies from one ROA to another one doesn't want to disclose the information. Yeah, no, you can't go to the system to boss. No. Once that goes to the EG, that's confidential. Yeah, that could be messy. Because those are only done under an actual court order, yeah.
So does if, since we're talking about the UDO dying, does the nominee shareholder agreement then pass to the personal representative, or do they have to reconstruct because the UBO is gone? I understand that the shares themselves move over, but does the
Do you have the
agreement still stand?
That agreement now is between those two lawmakers, so you need a new one, even if he's still gonna be the nominee.
Yeah,
There'll have to be a new one.
yeah, because a new person.
I also can't wrap my head around why someone would want to be a personal nominee shareholder for someone. Like, why would I want to have my name on record?
Money.
Yeah, but then depending on the company, I don't want people to think like for someone who wouldn't know, for them, if there's a leak. And that.
A
goes out
lot
there,
of
you know, like,
people
I don't know
tend
if
to
you
shy away from it now. But let's just say, if you met Janet, you know her for years. You know, she does business in Mexico, so you've known about her doing her business, and she decides she wants to incorporate some company here. Do business somewhere else, you'll do it. But you have to know these people,
Right.
that's the key to it.
That's some serious thing like this.
Yeah,
Yeah.
and then
Yeah,
continue with knowing who
yeah, but it's not someone who you pick up off the street, you're not gonna do that.
experience is a serious thing, like real life experience.
Yeah.
Clients.
But a lot of
testify.
people have those, that's what
Information.
networking is about, you know. But remember, I can be honest today and dishonest this
But that's it.
afternoon.
Exactly,
That's
exactly.
exactly it, like a real life, client provide.
And I'm going
information,
based on past
And
knowledge.
then 2 weeks later, we asked for verification, and it all came, so now they can't provide any verification because they knew, like, they told us where they live, knowing that they were selling this place, and now they have really no actual formal place of residence, and we
Mhm.
like, the way you live, like, I need to know what you're doing, like, you want to go around the world, like, what's your residence, like, and they can't get anything because they up and down, trying to get residency here, trying to get residency there, and it's like, all right. And a lot of weeks.
Mhm. But a lot of people are doing that now, you know, they're living on boats,
Yeah.
going from jurisdiction to jurisdiction, trying to find a place to live. Yeah. It's common. It's common. It's common. And some people actually will incorporate a company in the jurisdiction. And then put all of their assets in the name of the company. And so their residence is where their company is registered, because they have no residence. They're living on a boat. Some people, they just live on their boat. So that's why the yacht business is booming now. You notice that, right?
Yeah.
The yacht business is booming. They're not staying in houses no more.
Something that we really have to look a lot, yeah, so because we have our third client. Who is open the company, the underlying company for the purpose of purchasing the yacht.
Mhm.
In the last one.
But that's, I don't know if that was what I'm pretty sure around with the read. Like they have a lot of, I don't know, it's probably because it's the course system too, but I get a lot of deals where they talking and they teaching people of how to incorporate a company and put your assets in so that you would not, you could kind of lower your taxes or you pay taxes in a sense. So there are actually people that's teaching Americans how to do it. I don't understand like the 401k and the REITs and all these things, but they have teachings on telling the Americans how to maximize.
Yeah, do something, so it,
So
something else.
just a regular Joe now,
I didn't minimize.
a regular Joe now opening up a company
Yeah,
for the
because,
purpose of.
yeah, because over here is do it online and it's
Yeah.
very easy. Very easy. And then they have different types of companies in the way in which they're worded. Because they incorporate like a lot of trusts, but it's not the same trust that we do. It's a business trust.
But then doesn't legally that goes back to, like, you're talking about just a regular person who doesn't have the experience. You go and you open up a company and you have you manage it on your own without like a real legal entity or whatever representing yourself. And if something happens, the court is still gonna hold you
Yeah.
at that level of prudency that you should have had the skill to do it. So I mean, is that a risk you really want?
No, some do. Some do, and they do it for whatever purpose and they just wind it up.
Yeah.
All right, ladies, that's it for me. I will see you all in a month.
Yeah.
What do you mean?
Sandra, I'm gonna email my stuff to you.
Well, you are expected to.
When is it due again?
Thursday. Question 2. The other one I wanted to date.
Oh, yeah, that's the one I need to email that.
Yeah.
It's been a rough 2 days.
Okay, Alicia, have a good week. I'm waiting on my paper.
2 weeks down.
Yes, ma'am. Just get it this evening.
Okay, same for you,
Thank you.
Siobhan and Lavette. Well, Lavette, you're sick, but no excuse. You had plenty time.
I'm Senate.
Okay, all right.
Thank you.
Okay, all right. Have a good week. Don't come to church.
I
All right,
wish you
yeah.
have a good one too.
Have a
All
good
right.
week, everyone. All right.
Okay, all right.
That's 2 weeks long. Okay, so I have 2 weeks.
You see that? And it wasn't bad, right?
Fine.
Okay.
I'm not gonna lie, for me, it was like, okay, I have to research like a lot of different terms.
That's fine.
And stuff, so like as I'm reading, it kind of takes away a little bit from my study time because I'm ready to learn, trying to understand exactly what the term means, how it's used, and so. I have a long studying session and sometimes I fall asleep.
Oh, that would come.
Like, oh, I'm studying.
Okay.
I don't know how work like this setup, but I something like that, stuff like that. So like every time I get like brain fog and I need 5 minutes to pick something different, I'll just open it and read a page. Oh my God. And it just go back to my book. That was happening to me. Like how people will take like a coffee break or a food break, like in that time, instead of me walking around in my brain. When I get too much, it's like some rule or something. Yeah, 15 minutes, I'll go and then it's like another 2 minutes for their brain to get to work. I'm just like, okay, let me look at this and read a paragraph. Okay. Just the parents. And also,
Yeah.
the benefit of that is it'll still makes you look busy all day.
That's a good one.
But those who don't have micromanagers, I guess.
Yeah, that's true.
Yeah. Yeah.
Is there a study group? Or are we creating a study group?
It's so easy. This is so easy.
Just stop it now.
Let me tell you, the good part is everyone is working in that area already, so they can click it as they do certain things.
True, yeah, she needs a,
You're still in.
So a lot of times, they something that
Not in the area either, so.
They don't have to.
I have the same
Yeah,
struggle.
in real estate.
Yeah, we have a problem, yeah.
So like all of this is like,
Brand new.
Right, like completely brand new, and I'm just learning this. Area.
Yeah, I was thrown into the fight. So some of lot of these things now are now that.
Oh, that's why I do that.
Well, I'm not impressed with that. I am sorry.
Yes.
she said formal group.
Yeah,
But
I was thinking about who's holding all the contacts. I'll make the email with that.
So good.
Oh, yeah.
you wanna come to she?
One number.
I mean, I think I'll just give her my number so she can phone with
Yeah, give her that.
whoever, yeah,
Okay, all right.
whoever's interested. I know.
And thank you for coming on time, ladies. Just don't be late for Denise next week. I don't know what time she comes.
Okay. Well, don't miss us so much. We're gonna miss you, but time is flying.
Yes. Going fast. What are you gonna do there?
Piazza, 465. 391. Leo, Leah. 8170884. Bye, y'all. Morning.
Y'all see a message from me, I'm just coming to the humble hearts.
Yeah, oh yeah, you got to send me the group link. I'm involved in Rotary. So if I didn't turn off my, you can't add me to a group, I would be in 100 groups. I really like this man. Cause I was doing leadership stuff in Rotary, like everybody meeting in the group and then sometime.
I'll just message through them.
Yeah.
I'll probably just message everyone. I don't know if everyone would want to be in a group. I don't know. We can always make arrangements to study.
Yeah.